So the Supreme Court just granted review of a case which can actually help bring an end to the ATF's current overreach and their attacks on the Second Amendment. So let's talk about this. But real quick before we jump in this video, I want to thank everybody who's supported the channel. We just recently, yesterday, reached 500,000 subscribers. So just wanted to say thank you to everybody for supporting the channel. Never would have thought I would ever reach 500,000 subscribers. And I just want to mention that if you're not currently subscribed or if you're a longtime lurker, consider subscribing. And now we're moving towards our goal of 1 million subscribers. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we're going to be discussing an important case which the Supreme Court has now granted review of, and they will now decide on. This case is not a Second Amendment lawsuit, but it still has huge implications for two-way litigation and litigation right now going on against the ATF to stop their current overreach. This case we will be discussing is called Loper v.Raimondo, and this is a lawsuit which aims to bring an end to Chevron deference. Now, the facts surrounding this case are as follows. Loper Bright Enterprises is a family-owned herring fishing company that operates in New England. However, the herring industry in the area came under attack by an executive agency because of a new rule issued by the National Marine Fisheries Services, which is also known as the NMFS. This new rule that they put in place requires that the herring fishing boats must have an additional person on board to serve as a monitor. The rule requires this additional monitor so that the boat is in compliance with federal regulations in regards to tracking compliance. Not only does this additional person, this monitor, take up space on the boat, but the fishermen also have to pay that individual salary, which is estimated anywhere between like $700 per day. And if the fishing boats decline to have that additional person, to have that monitor on board, then they're going to be prohibited under the new rule from being able to fish. In response to this new rule, Loper Bright and other fisheries sued and challenged the new rule, arguing that the NMFS lacks statutory authority to force them to have and pay these monitors. Now, on review, a district court held that the statutory text did authorize this new rule. Loper Bright then appealed that decision by the district court, and it went before a DC Circuit Court, and the DC Circuit Court held that the statute was ambiguous, but then the court deferred to the agency's interpretation of that ambiguous statute under the doctrine of Chevron deference. Loper, in response to that, then filed a petition up to the Supreme Court for Supreme Court review, and this whole video is in regards to the Supreme Court actually granting review of this case. In Monday's order, the Supreme Court stated that the petition for a writ of certiorari is granted, limited to question 2 presented by the petition. Justice Jackson took no part in the consideration or decision of this petition and these motions. Now, question 2 that the court is referencing there in their granting of review is the question that Loper presented in their petition. That question is whether the court should overrule Chevron or, at the least, clarify that statutory silence concerning controversial powers, expressly but narrowly granted elsewhere in the statute, does not constitute an ambiguity requiring deference to the agency. So the Supreme Court will hear this case and decide whether or not they want to overrule Chevron altogether, or at the very least, are they going to limit the ability of an agency to use Chevron when a statute is silent on an issue. Now, if you're not aware of what Chevron deference refers to and what we're talking about here, Chevron deference is a term coined after a Supreme Court case called Chevron v. Natural Resources Defense Council. The case established the concept of courts upholding an agency's interpretation of an ambiguous statute that Congress has tasked that agency with implementing. However, generally for an agency, for example, like the ATF, to be given Chevron deference, the agency's interpretation of an ambiguous statute must be rational or reasonable. So when a statute is ambiguous in some way, the agency responsible for enforcing that statute may be able to determine what Congress intended as long as their interpretation is deemed rational or reasonable by a court. Now, in contrast to Chevron deference, there are other concepts that a court could use. For example, the rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous statute in the way that is most favorable to the people, not the enforcement agency. There is also something called the major question doctrine, which the Supreme Court just recently used in a different case that they ruled on, which was West Virginia v. EPA. Under the major question doctrine, the Supreme Court declared that if an agency seeks to decide an issue of major national significance, its action must be supported by clear statutory authorization. However, in all this context, there has not yet been a complete obliteration of Chevron by the Supreme Court. There's been discussion by the Supreme Court and various justices like Justice Gorsuch, who said that he wanted to essentially put Chevron deference to bed, but we haven't seen that yet. And this case, Loper, appears to be what the Supreme Court is going to do. It appears that the Supreme Court is finally going to take up this issue of whether or not they actually want to completely do away with Chevron, or if they want to very significantly constrain the powers that an agency has, even if they're going to try to use something like Chevron deference. Now, you may be asking yourself at this point, why is this important? Why is this important for the Second Amendment context? Well, right now, you are seeing agencies like the ATF and other federal agencies being very aggressive in their current rulemaking processes. For example, the ATF in just the past 5 years has made multiple new rules through rulemaking processes. They've done this through issues like the bump stock ban, essentially, where they treat bump stocks now as machine guns. They put in place a rule that further regulates polymer 80s as unfinished frames and receivers. And recently, right now, we're dealing with the issue of the new rule, which are regulating braced pistols as actual SBRs and subjecting them to the NFA's restrictions. Now, this is all being done through the ATF claiming that they have broad statutory authority given to them under the NFA and GCA to make these types of rules. If Chevron is completely done away with, then the ATF's claims that they have this type of authority will no longer be valid. Now, one other thing that I want to point out that maybe you don't hear other people talking about on this specific case and issue, I do want to point out that the ATF itself has kind of seen the writing on the wall. And a lot of these litigations that they are engaged in, like the bump stock ban, the frames and receivers issue, the pistol brace rule, a lot of times the ATF is actually not even raising Chevron deference anymore. They are in fact waiving Chevron deference. And that is because they've seen the writing on the wall and they know that eventually Chevron will be done away with. Instead, the ATF's been arguing that the text of various statutes like the NFA and GCA are expressly giving them the ability to do these types of rules, to do this type of conduct in regulating, for example, bump stocks as actual machine guns. Like in the bump stock lawsuits, the ATF has claimed that the term machine gun is very clear within the statute, and that very clear term, in fact, includes bump stocks. So they're not saying that it's ambiguous, that the statute's ambiguous, and therefore they're going to use Chevron deference. Instead, they're saying, this is a very clear statute. We are saying machine gun is a clear definition, and that clear definition includes bump stock. So you can see a different tactic that the ATF has taken recently, and that's because of this whole question on Chevron deference and the indications of the Supreme Court saying that they want to do away with Chevron. So it'd be really dumb for the ATF to put all their eggs in the Chevron basket when the likelihood has always been that eventually this current Supreme Court was going to do away with it. However, the Loper decision will go a very long way to prevent liberal judges and courts from deferring to the ATF's current anti-gun agenda, because even sometimes when the ATF has waived Chevron deference, when they haven't even brought that up in their own defense, sometimes these left-leaning liberal judges and courts will still say, well, it doesn't matter that the ATF waived Chevron deference, we're still going to give it to them, and we're going to say under Chevron deference, these types of actions are permitted by the ATF. So it's going to go a long way to prevent those types of scenarios, and then literally just pretty much leave the ATF to only having one type of argument to raise in their defense. So that's what's going on with the Supreme Court taking up a case which seeks to do away with Chevron. If I get any more information, I will let you all know. So if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.